back to Litigation Help. My name is Heather Hoyt-Twin, and in this video, we're going to talk about the differences in rights and obligations between being legally married versus being in a common law relationship. So joining me here today are two lawyers who specialize in family law. Helena Birt is the Senior Program Director of Ontario's Family Law Limited Scope Services Project. She runs a private practice in Hamilton. Her information can be found below in the description. Helena has appeared on another video which explains what unbundled services mean. So check that out by clicking on the link above or in the description below. John Paul Boyd is a family lawyer and arbitrator whose practice is in Alberta and British Columbia. John Paul has also been a guest on many videos on this channel. So don't forget to check out his series on arbitration. And we also recently have a podcast on how to de-escalate conflict. So don't forget to check that out as well. He also has his own YouTube channel, 5 Minute Family Law with John Paul Boyd QC. I will, of course, have the link for you in the description below as well. So welcome both.
Hello.
Thank you. Hi, Heather.
Hi. So Helena, let me start with you. So when I'm talking about common law couples, what exactly are we referring to? Obviously, it's not two best friends living together, right?
Hopefully they are, but you just know. We'll have to see how it goes. But no, I think what you're trying to get at is the fact that there are people who will choose together as a family or a couple without benefit of marriage. And that really, to me, is the primary distinction between being married and cohabiting in that kind of relationship, is that when you get married, it actually creates a change in your legal status. And once you've created that change in your legal status, there are a whole lot of rights and obligations that automatically become yours just by the fact you've gotten married. And there are written rules that apply to what those exactly are. The key thing is that if you are living together without benefit of marriage or without the anchor of marriage, as some people will look at it, then the rules that apply to you can be very different than they are when you are married. Generally, in order to be in a cohabitation relationship, and again, we tend to try to avoid using the term common law relationship anymore because the whole definition of why it was there is not there, but unless you're a law student, you're probably not going to be really interested in why that's there. But in a cohabitation relationship, you are basically putting yourself in a situation that is equivalent to married without the change in your legal status. You can create a family that way. Then what we're going to be talking about for the rest of this program are the differences between what those rights and obligations are when you're married as opposed to when you're living together. Living together, generally, though, the way that we talk about it as cohabitation means that you're in more than just a platonic relationship, as you would if you were living with a roommate. Sex is normally considered to be part of a relationship. It's one of the pieces of evidence that might be looked at later to decide if in fact you were living in a cohabitation arrangement, or were you just roommates, or were you in a landlord-tenant situation. But if you are living together in the relationship where the proof and the evidence is there, and you're choosing to be a family or a couple, then what we can do is talk about what your rights are about property that accumulates during the time that you are together as a couple, and what happens if you have kids of that relationship. But that's basically the big distinction, is cohabitation means deciding to create a couple or a family without having to be married first.
To add to that is that the language that we use to talk about these kind of unmarried relationships changes as you go across the country. The other things that change are the legal requirements that you have to meet in order to qualify as having that special unmarried relationship status in your jurisdiction. So for most federal laws, including things like the Canada Pension Plan legislation, the federal language talks about people who are common law partners. In Alberta, on the other hand, people in long-term cohabiting relationships are known as adult interdependent partners. In British Columbia, they're called unmarried spouses.
Yeah, so Helena, so it's good that you mentioned some of these aspects like property. So John Paul, I want to turn this question to you. Can you tell us how property division differs between a divorce situation versus a common law separation?
Yes. Common law relationships were at one point unrecognized by the provincial legislation on domestic relations. It wasn't until the 1970s when the provincial laws began to extend rights of spousal support to unmarried relationships. And really, it's only been in the last 10, maybe 20 years that property rights have begun to extend to unmarried relationships as well. But what those rights are depends on where you happen to be in the country. And that's because divorce is a subject of federal legislation, and along with divorce goes the federal rules about parenting after separation, child support, and spousal support. But the rules that apply to people in every other kind of relationship other than married relationships are provincial. And of course, each province has the right to make its own laws. And so as a result, one province's laws are not necessarily the same as the others. So, for example, Manitoba, Saskatchewan, Alberta, and British Columbia now all have property rights available for long-term unmarried relationships that are exactly the same as the rights that pertain to people in married relationships. It's not quite the same in the other provinces. And this is really, relatively speaking, a new development. For example, in British Columbia, unmarried couples didn't acquire that kind of like marriage property rights until 2013. In Alberta, they didn't get them until September of 2020.
And again, in Ontario, we are one of the ones where we are still in the regime where basically, as an Ontario lawyer, if you're an Ontario resident, you're going to talk to a lawyer. They're probably not even going to mention the fact that the regimes are different in other provinces. In Ontario, if you're in a common law relationship or a cohabitation relationship that breaks down, there are no special rights or rules that have with respect to division of property. It would be the same as if you were living in a platonic relationship with a roommate and you're no longer going to live together. Whoever can prove they bought and paid for something gets to take it with them. But that is very specifically the case in Ontario and not necessarily out west. And I'm not even sure what it does out east.
Yeah, and so in situations where the provincial law doesn't extend any particular rights, property rights that is, to people in unmarried relationships, the general rules are that you're each presumptively entitled to one half of the things that you own together, right? The things that are registered in your joint names, such as cars, planes, trains, automobiles, and the family home, if of course all those things you bought together and they're registered in your name. The problem really comes up in unmarried relationships because unmarried relationships can last for 2 years or they can last for 20. And the problem comes up when, people have been carrying on as if, well, this is of course my house when it's only owned by the other person.
Mm-hmm.
And, you often find situations where somebody devotes a lot amount of time to, renovating the basement or redoing the landscaping or, putting an extension on the house. And when they separate, they find out that lo and behold, they don't have any presumptive entitlement to the house, even after all the work they put in. And so for unmarried people in provinces like that, the law revolves around something called unjust enrichment. And that's a really difficult concept to explain. And it's why Helena's remarks about going to see a lawyer are so terribly important. From a lawyer's point of view, there are a bunch of legal tests that you have to meet to establish that you have this entitlement to share in some part of the value of your partner's property. But how much that is really difficult to figure out. It really is managed on a case-by-case basis, and those claims are hard to prove. So you really do need to speak to a lawyer.
Yeah, and they all come down to a question of fact. It's not like being married. If you can produce a marriage license, bang, the rules that are set out in the legislation under the Divorce Act will apply to you. And the way that it works in Ontario is that if you are married, the rules are very clear on the accounting function and go through how to deal with community of property in Ontario if you are married. If you're in a common law relationship, really, the way that you almost have to start looking at it is to step away from the fact that you were in a romantic relationship with somebody for whatever period of time and just say, all right, if we take the romantic relationship out of it, how can I prove that I actually put value into an asset that is owned by the other party, and how do I get that out? So it becomes very, very much a question of facts and evidence that have to be proved, and it can be very difficult. That's one of the caveats, and I think you're going to be asking us about these later, is sometimes it's really, really a good idea, if you're thinking that far ahead, to consider entering into a cohabitation agreement, or even if you're getting married, a prenuptial agreement, or a marriage contract, because you can change the rules and you can define for yourself in many areas what the rules are going to be in the event the relationship doesn't work out and you end up separating.
So am I correct in understanding, and I'm going way back in law school now. To me, it seems like, so for married couples, you've got legislation that's very clear, right, about a property division. But in terms of common law relationships, you have the common law remedies. You have, what you mentioned, unjust enrichment. That's a common law uh, remedy,
It's
right?
essentially an equitable remedy, but that means pretty much the same thing. Yeah.
Right, right. Now, speaking of matrimonial home, I think a lot of people are concerned about that part because that is like the biggest asset usually that couples have. Can you speak to, is there any difference in the way the matrimonial home is treated in a common law relationship versus a legally married situation? Who wants to take this first? John Paul, maybe can you start us off?
Well, again, it all depends on where you live, right? But first of all, if you're in an unmarried relationship, it wouldn't be the matrimonial home. It'd be the family home, something like that.
Family home, okay, yeah.
So the rights that specifically relate to the family home depend on where you live, right? So as I've mentioned before, in Manitoba, Saskatchewan, Alberta, and British Columbia, the rights that unmarried people have, providing they're in relationships that meet the legislative definition, are exactly the same as the rights that married people have. In Alberta and British Columbia, there's no special provision made about the family home in terms of giving it special rights that are different than the rights that relate to other pieces of property like RRSPs or cars or a cottage or something like that. But in Ontario, there are specific rules about the family home. And Helena, maybe you can talk about those.
Mm-hmm.
And basically, the way that the regime works in Ontario, if it is a family home as distinguished from a matrimonial home, i.e., not a home belonging to a couple who are married, its division is and property rights are decided on the basis of title and ownership. So if you are in a cohabitation agreement and you are living in a home which is registered in only one of the parties' names, and it doesn't matter if that, let's say that that person owned the home and you're the female partner coming in and you move into your partner's home and then you're together for 8 years and you take out a loan and you put renovations into the home, but there's nothing secured against the property, you're increasing the value of property that is owned by somebody else. So again, if you do that step back and say, all right, you're doing this with a roommate. If you don't own that asset, you should be getting something in writing to say that if and when that home is ever sold, you need to do something to get your money back out of it because you've increased the value of that home. But in Ontario, if you are not in a marriage situation, there are no rights to a division or claim in the interest of property unless you can bring, as John Paul had said, the special unjust enrichment kind of claim, or you have an agreement in place to the contrary. What a lot of people don't realize is even just the right to possession of a family home in Ontario. If you are in a home that is registered in the name of somebody else, or if it's a rental apartment and the lease is in your partner's name and you're not married, if the relationship falls apart, the police are not going to assist you. You have no right to claim that you have the right to stay in that home because it's not your home. It belongs to the person in whose name title is registered. If it's in both your names, then it's going to be a question of saying, well, it's an asset that you have to figure out how you're going to do that, and it gets kind of touchy. In Ontario, and I'm really glad, I wish that we would in Ontario be able to move more towards the regime you're using out west, JP, because still even here, there are an awful lot of problems where we have a violent breakdown of relationship and the police are knocking at the door and they believe that it's the same rights to possession as it would if it was a married couple, and they're giving people legal advice about what they can and can't do, which is actually incorrect. Like, again, even if you're an abused spouse, if you're in a cohabitation relationship and you're in a home that is owned or the lease is in the name of your partner, you have no right to stay there. If there's been violence and one of you has to go, the police can't make him leave if it's his property.
I think part of the problem is that people misuse the legal language all the time, right? We talk about, this is my common law husband, this is my common law wife. Well, there's no such thing. And you don't want to accidentally confuse yourself by thinking that your relationship is exactly the same as a married relationship. It's not. In the prairie provinces and on the other side of the Rockies, there really is no difference between a married relationship and an unmarried relationship. You have exactly the same rights and entitlements. The only difference is that it's the poor suckers who got married who have to pay to get divorced. But in other provinces, in particular Quebec and Ontario, where the regimes are very different, You just cannot proceed on the assumption that your rights and entitlements are exactly the same rights and entitlements that you would have if you were married. So what Helena was talking about the family home, that's exactly it, right? If you are both on title of the family home, you're both presumed to be equal owners of the house, subject to arguments that you can make about, well, I put in more to this and you put in more to that. But if you're not married, you don't have the special presumptions about how the family home is dealt with that married couples have. And instead, you're stuck with looking at the title and saying, well, am I a co-owner or am I not? And if you're not a co-owner, then you wind up getting sucked into this mire of the unjust enrichment claim. And if you just cross over to the next province and you go to Quebec, you'll find out that unmarried couples have almost no rights except with respect to their children. Unmarried spouses in Quebec are not entitled to spousal support, for example. So the rights really change depending on where you live. And it's really important that you go to organizations that provide public legal information to learn about what your rights are and to make sure that you're not making the mistake of assuming that because you've been together for 25 years that you have exactly the same rights as a married couple would. It just doesn't work that way.
We got to keep repeating it over and over again. Will depend on which province you're in. So just don't go online and Google information that might not be from your own home jurisdiction, because it might be 100% accurate for where it came from, but it ain't going to apply to you necessarily.
Yeah.